the technical sense that it means,
and particularly for purposes of judicial proceedings. Your Honor, articles, not section, Your Honor, under section 256. Offense is defined as follows: any person who by force, compels, or by deceitful means induces any persons to come from any place is said to abduct that person. Any person who by force, compels, that's the first part, or by deceitful means induces any persons to go from any place is said to abduct that person. That is section 256. In the circumstances of the case, we are relying on the first part, the use of force, which was witnessed during the so-called rearrest of the accused persons before you. There was force used to get them from the courts and now to present them before this court. Your Honor, we have gone, the definition, I believe my learned friend from the LSK, our DP, Maura Kabata, defined to the court how an arrest should be conducted and pursuant to a reasonable apprehension that an offense has been committed. All that is on record. The point that requires emphasis is that the accused persons had been, let's assume they had been lawfully arrested. They had been lawfully arrested, but in the course of processing bail pursuant to court orders, they were grabbed from the registry while processing bail. Clearly, this was done not pursuant to any apprehension, but to defeat the orders that had been made by your learned colleagues. You can say there is nothing technical that can be able to enable any person using common sense and blessed with reasons by the Almighty God to interpret it any other way. That they were grabbed from the court registry to defeat the orders of the court setting them free on board. In the case of Bennett versus the Horseferry Roads Magistrates Court, the issue was precisely that if you ought to have brought Bennett from South Africa pursuant to an extradition order, and that order was not there, the court actually said, we cannot allow people to be tried in English courts people who have actually been abducted. Actually, the truth of the matter in Bennett's case, the discharge was on the basis that he was abducted. In the context of this case, and the law has always meant the Constitution, the statute, promulgated rules and regulations, and judicial decisions of the court and judicial orders. There was a judicial order setting them free. Over the same facts, the prosecution, I was waiting for that. The prosecution, I concede, if these two accused persons had committed terrorism act in Mandera, and Garissa, where this terrorism is actually perpetrated, it would have been a different ballgame. But it was the same offenses, the same set of facts that the courts had said that there is no basis why your rights under Article 49 should be derogated, because that was the issue. Whether the DPP and the police justified the derogation of fundamental rights. Those magistrates said there were no grounds for derogating their rights and to ensure that they were further detained. Accordingly, any attempt to arraign them before you in disobedience of court orders and to defeat the proper administration of justice cannot be countenanced under the principle laid out in Osfery versus Magistrate and in the Gedongori case, because it was the same case, abuse of power. Abuse of power cannot be countenanced, cannot be tolerated. Your Honor, the issue, you are told that there were no charges that were facing them. But you would read all the affidavit. And that is a specific argument that was made both in Kiambu and Roiro, where I was there myself. They said, we are holding these people on the basis of specified offenses that are being cited today. And the issue for purposes of Article 49 of the Constitution is not the charge sheet, which is a legal document. It is, what are the offenses against this man and woman? The offenses were set out in an affidavit. So when today you are told we have a charge sheet specifying a terrorism act, this is a fiction used to justify disobedience of the law and to justify abuse of power. Because if it is permitted to proceed as such, and that is a bigger question, the courts would effectively have lost control over the persons brought before it for purposes of any prosecution. There are two small points. Your Honor, you are referred to certain provisions of the law. There is this issue that has repeatedly, you've been told, we are seeking judicial review of the decision to charge that has been made by the DPP. There is no doubt that the DPP can make decisions touch. There is equally no doubt, Your Honor, that the laws, the relevant laws says those persons will be charged before a magistrate. Laws in Kenya, as we understand, the first business of any court is to be satisfied as to its jurisdiction. That it does not share with the High Court. It is a personal decision that you must be satisfied that you have jurisdiction. Jurisdiction can be compromised or negated by the conduct of the state or of the prosecution. So that, Your Honor, as an example, you cannot have jurisdiction in a charge sheet saying that Gachagua was killed yesterday. We can see Gachagua in court. There would be no valid charge. So that the charging, there are certain requirements that must be there. There must be some evidence Gachagua is dead. There must be some basis. If he was killed in Europe, if he was killed by Gachagua in Europe, you must show that Gachagua was in Europe. But if the Gachagua was not in Europe, where Gachagua was killed, it's clear you cannot say that you have a valid charge. Let us wait for the DPP and the police to give us evidence. There is no such thing. So that, Your Honor, it was the same thing that was in Roiro and Kiambu. That what is it? In Roiro and Kiambu. That what is it that you have? The court said there is nothing. And the DPP was saying we need 21 days. When we talked about reason, the court, the reason that must be used is, since you have been praying for 21 days yesterday, and it has just been denied, they are saying, decided now to charge. On what basis are you charging? You said it in an affidavit, you need 21 days. In the course of the bail being processed, you rearrest, or you abduct and call it a rearrest. You know, this is a mischief rule. The court must go to the mischief rule. The last 2 points on the Constitution is this. About your authority that we need to go to the High Court. First of all, I like the idea. The prosecution keeps mentioning the High Court. But what is good for the gander is good for the goose. If you see there are certain things the High Court can do, it must start with you. The police and the DPP disagreed with the magistrate. The law is clear. You could only change that by going to the High Court. So that the High Court cannot be held only against us. That you say, when you are supposed to go to the High Court, you abduct to avoid the High Court. When somebody else says, the magistrate protect me, you say, no, magistrate, you cannot protect. Go to the High Court. It can't work that way. Your Honor, that is not the law. But more importantly, it is my submission, based on 2 clear provisions of the law, before my learned senior, Mr. Kalonzo, proceeds with this, that there are clear provisions of law. Article 21 had been cited by my learned colleague, Mr. Ondieki, 21 and 4 of the Constitution. Under 21 and 4 of the Constitution is, first of all, 20, the general subject of Article 20 of the Constitution is that it deals with the issue of application of the Bill of Rights. 21 says the Bill of Rights applies to all and binds all state organs and all persons. Your Honor, you are a state officer. So 21 refers to you and says that the Bill of Rights applies and you are required to observe it. But more importantly, 20 sub-article 4 is very clear. In interpreting the Bill of Rights, a court, a tribunal, or other authority shall promote the values underlying an open and democratic society based on human rights and dignity, the spirit, purport, and object of the Bill of Rights. So that it doesn't leave anything to the imagination. You have jurisdiction to do so. And finally, Article 23 of the Constitution. Article 23 of the Constitution deals in saying that for purposes, that is 23 sub article 2, Parliament shall enact legislations to give original jurisdiction in appropriate cases to subordinate courts to hear and determine applications for redress of a denial, violation, or a threat to a fundamental rights in the Bill of Rights. Your Honor, there is a law that Parliament should make to make clear the nature of the jurisdictions. We have the Mutunga rules for the High Court. Under 23.2, a certain law should be made. But where a law has not been made, the authority given by the Constitution is exercised directly. It doesn't require any law. So you apply that authority as you understand it. So we are perfectly entitled to say that there is a violation of constitutional rights and to seek some protection. Finally, the broader point is this. Your Honor, on day one, and it is already in the newspaper, that a person is charged before you. Person is charged before you. His son's trial on the basis of a specific label. We have charged thing to be told evidence will be given when a trial is starting on the basis of conscientious citizens of Kenya exercising their rights under the constitutions to start to be labeled as terrorists, because they will be the first ones. So, Your Honor, I urge you to consider everything, the scope of this. It is much bigger than the prosecution is making out to be. Because to permit this, it would literally allow the 4,000, 5,000 people that we've been told have so far been arrested to be tried as terrorists. Your Honor, Kenya will cease to be a constitutional democracy if such a precedent were to be set. We have made the objections here. I urge that you uphold the constitution. You are most obliged.